Meeting. Welcome all. We have two of our guests today appearing by video conference. We have Mr. Jean de Wet, who is the Chief Executive Officer, Transparency International Ireland, coming to us by video conference from Dublin. We will also be joined by Mr. Tom Devine later this morning. He informed us he would be a few moments late, but once he appears, we will get his testimony as well. And in person, we have Madame Joanne Gouliard. Gautier, thank you very much, from the Integrity Principle. Colleagues, we have 1 hour for these three witnesses. I understand all three witnesses have brief opening statements, approximately 10 minutes each. So that will leave us approximately 30 minutes for testimony and answers from our committee members, which means we'll have one 7-minute round of questions, and then we'll move to our second panel. And with that, Mr. de Wet, could we start with you, please, your opening statement?
Thank you, Mr. Chairman. It's a great pleasure to present to the committee, a great honour as well, and I'm more than happy to assist the committee in its deliberations around reform of Canadian whistleblower protections. I'll talk to you briefly about how the Protective Disclosures Act in Ireland came about, key features of the Act, as well as some of our observations around potential impact, the impact of the legislation here in Ireland. By way of background, I'm Chief Executive of Transparency International in Ireland. We have been working on whistleblower protection for about 10 years now. Launched Ireland's first and only free phone helpline for whistleblowers in 2011 and have assisted around 900 people so far. We've also assisted the Irish government in drafting the Protective Disclosures Act in 2014. We provide advice to the Council of Europe, the United Nations Office on Drugs and Crime and other agencies, and have been offering assistance to other governments in their deliberations around whistleblower protection. We started exploring this issue in some depth back in 2009 and published an assessment of legislation in Ireland. Up until 2014, there were around 18 pieces of legislation on the statute books governing how individuals should report a concern and the kind of protections they would be afforded were they to make a disclosure. We found that whistleblowers were afforded varying degrees of protections depending on where they worked and the type of wrongdoing they were reporting. So one could report a breach of the Pensions Act or the Chemicals Act or the Communications Regulation Act. But up until 2013, if you worked in a bank, you weren't afforded the opportunity to report or to report with the knowledge that if you did suffer reprisal, either informal or formal, that you would have any rights to seek redress. It wasn't really until the collapse of the Irish banking sector in 2008 that the Irish government took the issue of whistleblowing seriously. Transparency International had been campaigning for some time. In 2010, we published a report which led to a degree of consensus across party lines on a need for stronger whistleblower protection. And we had been campaigning for a single piece of legislation similar to that which has been on the statute books in the United Kingdom since 1999, which would afford whistleblowers protection irrespective of the type of wrongdoing they were reporting or where they worked. So we campaigned for what became the Protective Disclosures Act in 2014. The Act draws from best practice in the United Kingdom, New Zealand, South Africa and elsewhere. It focuses on workplace whistleblowing. It applies to all sectors of the economy, and it protects anyone so long as they have a reason to believe what they were reporting is true. False disclosures are not protected, or shall I say, Um, False disclosures where the individual is found to have known they were false are not protected. So someone can avail of the protections so long as they can show that they had a reason to believe what they were reporting was true, even if it transpires that the information they shared was misleading or false. Past disclosures are also protected, so any disclosures made prior to any disclosures of information related to wrongdoing prior to 2014 are protected. And one of the unique features of this legislation was the fact that it was the first to remove the requirement to demonstrate good faith. So the motivation of a whistleblower is irrelevant. There is, furthermore, no public interest test in the legislation. All one has to do is show that they had a reason to believe that the type of wrongdoing that is categorised in the legislation was taking place or was likely to be taking place. All workers are protected, with the exception of volunteers, which is something we would like to see addressed in forthcoming review of the legislation here. So contractors, agency workers and trainees, interns working in hospitals are protected. All one has to do is also show that the information they're sharing is relevant. So relevant information is defined clearly in the legislation and is related to type of wrongdoing described in the law. It also has to, the information also has to have come, is information that has come to the whistleblower or the worker in connection with their employment. And again, so long as they have a reason to believe that the information is true, they are protected. The type of wrongdoing covered is similar to the wrongdoing categorised in the Public Interest Disclosures Act in the United Kingdom. So it includes offences, breaches of legal obligation, excuse me, miscarriage of justice, health and safety issues, damage to the environment, unlawful or improper use of public body funds, oppression, discrimination, gross negligence by a public body, and concealment of information in relation to any of the types of wrongdoing above. Workers are protected from unfair dismissal, penalisation, so that might include bullying, might include relocation, informal sanctions, ostracisation at work. There's a burden placed on the employer to prevent a worker from being bullied or suffering any harm or detriment arising from a protected disclosure. Also uniquely, the Irish legislation provides a right of tort, so an individual can seek redress through the courts where they believe they have suffered harm as a consequence of making a protected disclosure. In addition, an individual has a right to take action against anyone who causes them harm where a disclosure, a protected disclosure, has been made by somebody else, such as their family member or a colleague, and they themselves suffer as a consequence of that disclosure, where, for example, they might be suspected of having made a protected disclosure, but they were not the person who made the disclosure, but suffer nonetheless. Whistleblowers are also granted civil and criminal immunity for making a protected disclosure, and their identity is protected from being released without just cause. Also, the law provides for interim relief for whistleblowers, so they can, within 21 days of receiving notice that they might be dismissed, and they believe their dismissal is a direct consequence of having made a protected disclosure, can seek redress through the lower courts, and the lower courts can prevent their employer from dismissing them and instruct the employer to reinstate them and keep them on the payroll until such time as their case is being brought before the employment courts, the Workplace Rights Commission. An employer has an obligation not to dismiss someone making a protected disclosure, not to penalise or harm an individual or allow others to do so. Again, they have an obligation to protect the identity of a whistleblower. They also cannot contract out of their obligations, so they cannot write gagging clauses into contracts or post-employment agreements into settlements. Public employers must put protections or procedures in place. So each public body has to have policy and procedures in place and must also report on the number of cases brought to their attention to the relevant government departments and the action taken. In addition, then a whistleblower can report to their own employer, to if they're working within a public body, to the relevant minister or to a legal advisor. And all they have to do in such cases show they had a reason to believe wrongdoing is taking place. If they have no confidence that their employer is taking or will take their concerns seriously, or they have reason to believe that the information they're disclosing is substantially true, there's substance to their allegations, they can report to a prescribed body, which is, generally speaking, a regulator responsible for governing that particular body. If in the event that they don't have confidence in their employer or the prescribed body, that they believe that their concern might lead to reprisal, where they can show that they're not personally benefiting or profiting from the disclosure, and other circumstances or conditions are met, such as the concern is being raised and it's believed to be reasonable in all circumstances, they can report to a journalist or a member of Parliament.
Mr. Devitt, unfortunately, I'm going to have to cut you off there. We're well over the 10-minute time we've allocated for opening statements, and we do want to have an opportunity for our colleagues at the committee to ask questions. So I'm sure that much of the information you may not have gotten to will come forward during the question and answer period, and I apologize for the interruption. Mr. Devine, I understand that you are with us now from Washington?
Yes, sir.
Sir, we will get to your testimony immediately. We're asking for a 10-minute or less opening statement. That will be followed by another presentation here in Ottawa, and that will be followed by questions from our committee members. So, sir, if you're ready with your opening statement, the floor is yours.
Thank you very much, Mr. Chairman. It's an honor to be participating today. Whistleblower protection is really riding the wave of a global legal revolution. 35 nations and 6 intergovernmental organizations, including the UN, the OAS, and the World Bank, now have whistleblower protection policies. In 1989, there was only one, the United States. GAP has helped to draft or enact 33 U.S. or global whistleblower policies or laws, helping 8,000 whistleblowers since 1977. So we're speaking from a base of experience. And our primary lesson learned is that weak rights actually are counterproductive. They increase the chilling effect and associated secrecy when rights in practice do not reflect the reality, when the rights on paper do not reflect reality in practice. As a result, organizations like the Council of Europe, the Organization for Economic Cooperation and Development, and groups like ours have developed best practices that distinguish effective whistleblower laws, which I nickname metal shields, from ineffective laws or cardboard shields. If you go into battle with a metal shield, it's dangerous, but you got a fighting chance to survive. You go into battle with a cardboard shield, you're going to die. Unfortunately, Canada's law is a paper shield, the global lowest common denominator. Its rights are not even in the same league as for African nations like Zambia or Ghana, or former communist nations like Serbia. Using 20 evaluation consensus criteria, the Act only passes 1.5, or about a 15% score. Let's consider why. The first criteria is a context for free expression rights with no loopholes. Arbitrary loopholes which are based on formality, context, time, audience, they dilute the law's potential for accountability. They're stopping up the free flow of information for accountability. And they also create confusion and uncertainty when it's safe to speak out, which causes an associated chilling effect. This law does not protect disclosures to co-workers, which are necessary for the homework to make responsible disclosures to law enforcement, to Parliament, to the public or the media, except in token circumstances. The second criteria that I consider, and I consider a dozen of the 20 that are most fundamental, is subject matter for free speech rights with no loopholes. It's a given that the whistleblower law must be protecting disclosures of any misconduct that betrays the public trust. But the Act does not cover the catch-all category for whistleblower laws or any anti-corruption laws, abuse of authority, which betrays the public, although it may not be technically illegal. It does not even cover Treasury Board regulations that are significant for procurement. A third criteria is protection against spillover retaliation. It takes a village of supporting witnesses, expert second opinions, and peer review for an effective, responsible whistleblowing disclosure. This law does not protect those who assist, who are associated with, or who are mistakenly perceived to be whistleblowers. Let's go to some criteria very significant for infrastructure. One of those is shielding whistleblowers from gag orders. Any effective law must override, cancel out, any prior or future rules that contradict or override its free speech rights. They can only be modified by amending the whistleblower law itself. But this law only protects against parliamentary restraints. Agency gag orders can cancel the national statute through internal controls. Settlement gag orders are free to lock in secrecy that conceals illegality or public health and safety threats, which is unacceptable for a transparency law. Or let's go to really the heart of this act, which is essential support services for paper rights through providing relief through informal investigations, in this case, the PISC. This is very important so that there's a legitimate channel for closure, isn't an alternative to due process proceedings that many unemployed whistleblowers can't afford. But in this act, with the PISC and its commissioner, whistleblowers have a toothless investigative agency that cannot even demand evidence of retaliation, that has a blank check not to, quote, deal with complainants' cases or their rights, has immunity for its actions, and operates in total secrecy. And this is to enforce a transparency law? Or let's go to the next criteria, the right to a genuine day in court. That's the foundation for any credible legal right. The right to the due process right to present evidence and confront accusers in courts reserved for society's highest stakes issues, if it's a whistleblower law. Under this law, there's no right to any in court. The PISC commissioner has to file the lawsuits for the commissioners and hasn't argued a case in court for over a decade. There shouldn't be any confusion. The lack of due process is the primary reason this act is not legitimate. And the rights in the law will not be credible until whistleblowers have the due process right to defend themselves. In fact, the law even cut out previously available court access, making itself the exclusive remedy. The final criteria for an effective infrastructure is realistic standards, legal standards to prove violations of rights. These are among the law's most significant features. They set the merits rules of the game for how much evidence is needed to deserve protection and for how much is necessary for each side to win. On the merits test for protection, the global consensus is the reasonable belief test. This is an objective test that information is credible for another person with similar knowledge or experience. Significantly, the whistleblower can be mistaken, although no law protects knowingly false disclosures. But this act uses the outmoded good faith standard. That's been discarded because first it's subjective, which creates an inherent chilling effect, and second because in many cases it led to putting the whistleblower's motives for disclosing misconduct on trial, even more than the alleged misconduct itself. Now, while motives are relevant for credibility of evidence, they're totally irrelevant for whether disclosing information should be protected. The point of whistleblower laws is to maximize the free flow of information from all witnesses who could help the public, not to make moral judgments about why someone exposed misconduct. The other part of legal standards is burdens of proof. Nearly all modern whistleblower laws also have a two-part reverse burden of proof. The whistleblower's burden is to prove a connection between protected activity and the damaging action, that the action was taken at least for partially illegal reasons. When that occurs, the burden of proof reverses to the employer to prove that it acted for lawful reasons independent of freedom of speech. This two-part reverse burden of proof is standard in almost all modern whistleblower laws. But Canada's Act has no burdens of proof. And my understanding from talking with NGOs here is that in practice, the burden is entirely on the whistleblower. This hopelessly stacks the deck. But once we get out of infrastructure, you have to have a realistic time frame to act on rights. You know, it can take a lengthy campaign to find a good lawyer and gather evidence to file a winning lawsuit. And with a short statute of limitations, employees may not even know that they have rights before it's too late to act on them. 6 months is the minimum. This act gives 60 days. Well, what's the bottom line for any whistleblower law? Relief for those who win. And unless there's a make-whole commitment in the law to compensate whistleblowers for all the direct and indirect damage from retaliation, they will still lose by winning, and the law will make the chilling effect worse. This has to also include the cost of litigation, such as the cost of hiring an attorney so that you have a chance to fight your case. Well, this act does not include the make-whole principle, and it has only token, dormant provisions for attorney fees. Now let's go to preventing retaliation, personal accountability for retaliation. Without it, through liability.
Mr. Devine, if I could get you to, I'm sorry to interrupt, Mr. Devine. I'm sorry, we're over time already, so I'm going to have to get you to wrap up very quickly if possible.
Thank you, sir. Without disciplinary accountability, there is no deterrent value to the law. There has been no discipline in over a decade with this law. Or there's credible corrective action, the primary cause for a chilling effect, even more so than fear of retaliation. There has been no significant corrective action in over a decade with this law. Folks, thanks for inviting me. The Government Accountability Project applauds. You're rolling up your sleeves for some very hard work, and you have our commitment that we will share any of our expertise and experience in helping you to accomplish that task.
Thank you very much, sir. We appreciate your offer of assistance. And finally, here in Ottawa, we have Madame Guerra-Thierry. Please, your opening statement.
Thank you, Mr. Chair, and thank you to all members of the committee. It is a great privilege to participate in what I believe is a critical and essential function, and that is to restore trust in our public service by locking in legitimate rights for the protection of whistleblowers. Briefly, I am a lawyer with 25 years' work in this field. In '98, I founded FAIR. Sorry, thank you. And I served as chair of the board for the Government Accountability, TOM's organization in D.C. I authored 2 private member whistleblowers bill and introduced in the House in '02 and '04, and I've testified to 5 different Commons and Senate committees. It is fair to say, no pun intended, that my entire professional work for over 2 decades has been given to promoting the need to protect whistleblowers and engaging the Canadian public in understanding the industry indispensable role they play in promoting accountable government. My clearest understanding of the mighty role that whistleblowers play in shining a light on corruption and holding powerful institutions to account is as a result of my own whistleblowing. In '92, I joined then External Affairs, and 5 months in, my life changed forever. I would like to share with you the betrayals of the public trust I discovered and endured, and the efforts at corrective action I took internally for 6 years, right up to the minister, and externally for 13 years in legal proceedings. But I can't because I am gagged. You must abolish this maneuver. In the absence of being able to speak freely, I will read from a newspaper article by journalist Greg Weston entitled "Enemy of the State." Joanna had just joined Foreign Affairs as a property manager when she got her first glimpse of taxpayer hell, a Canadian trade official's Tokyo digs costing over $350,000 a year in rent. Seems the official didn't fancy an $18 million mansion owned by the government in the same city, which sat empty for 4 years. Unfortunately, Canada's outpost of opulence in Japan wasn't the only diplomatic money pit taking taxpayers for a ride of the limo kind. Everywhere she went, Gualtieri discovered Canada's official face to the world was laughing all the way to the public purse. She screamed loud and long to her bosses. In her mind, she was just doing her job. Put simply, whistleblowers are employees who exercise their free speech rights to challenge abuses of power or illegality that harm or betray the public. They represent the highest ideals of public service: loyalty, honesty, and dedication. Let us consider their contributions. They saved lives. They succeeded in shutting down nuclear plants that were 97% complete because of shoddy building materials. They have compelled drug companies to withdraw dangerous and illegal drugs. In Canada, Dr. Nancy Oliveri, likely Canada's most prominent whistleblower, endured 20 years of legal battles because she refused to stay silent about a drug which her data showed harmful. Francis Kelsey, a Canadian hero, warned the FDA about the dangers of thalidomide. They didn't license it. In Canada, we did, and we know the legacy. Whistleblowers protect our national security. Pioneer Daniel Ellsberg risked everything when he disclosed secret files known as the Pentagon Papers about the lies and deceptions the American government promulgated about the Vietnam War. His disclosures to media are widely credited with bringing an end to the war. If there is ever a doubt about the necessity for the right to blow the whistle to media, listen to what Justice Hugo Black, writing for the U.S. Supreme Court, said. Only a free and unrestrained press can effectively dispose deception in government, and paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people and sending them off to distant lands to die. In my view, far from deserving condemnation for their courageous reporting, the New York Times, the Washington Post should be commended for serving the purpose that the Founding Fathers saw so clearly. In revealing the workings of government that led to the war, the newspapers did nobly that which the founders hoped and trusted they would do. I had the privilege to meet and talk with Frank Serpico, who blew the whistle on corruption in the NYPD. I wonder why we had heard so little of him, to only learn that the trauma led him to seek quiet refuge in Europe. Whistleblowers safeguard the public purse and innocent investors. Wrongful spending of public money is nothing new, and neither is cooking the books. Time and again, we have witnessed financial scandals: Enron, Nortel, the gun registry, HRDC, sponsorship Senate, where whistleblowing could have brought a preemptive end to the wrongdoing. So why do we do so little to protect them? The answer is again simple. Powerful institutions do not invite scrutiny. When faced with challenge, the instinct is to extinguish the challenge without ever considering the merit of the matter. So what must we do? First and foremost, we must recognize that leadership is the essential cornerstone of a change movement. Never has a government or politician in Canada shown consistent and passionate commitment to fight for the rights and protections of conscientious whistleblowers. Your contribution to public life and the health of our nation will be remembered by your commitment to this current undertaking. All else flows from these principles. Freedom of speech is a right, trust in our public institutions is paramount, and politicians owe a duty of care to their constituents. The preponderance of testimony to this committee has been about fine-tuning the legislation. Some presenters have employed negativity and even ad hominem attacks against the Public Sector Integrity Commissioner himself. With 25 years' experience, this approach, in my view, misses the point. It is like building a fire station without any fire trucks, a law without the prerequisite processes in place to drive the law, without the cultural revolution required to educate public about the existence and benefits of the law has little relevance. The first order of business is to engage in broad, meaningful, educative movement at the grassroots, not with academics and consultants, but real-life whistleblowers. They need to be heard. Second, in parallel, we need real protection laws, not paper shields, as Tom says. Without real protection, it is presumptuous and immoral to ask whistleblowers to step forward. Martin Luther King Jr. said, "Morality cannot be legislated, but behavior can be regulated. Judicial decrees may not change the heart, but they can restrain the heartless." Herein are the 5 key elements of any credible whistleblower protection law. Full free speech rights. Tom has already spoken to this. Remember, we have a constitutionally guaranteed freedom of expression, and this means that a whistleblower should be able to self-determine how to blow the whistle. In theory, PSIC is a sound idea, but 2 points must be made. First, it is naive to believe that an office like PSIC has the power, independence, and resources to take on cases of monumental impact and embarrassment to government. By definition, it is not a failing of the commissioner, but a structure of the commission itself. Despite a $60 million budget, Justice Gummery could not get to the bottom of the sponsorship scandal. To highlight the absurdity of a law which imposes exclusive domain in PSIC, consider the following. In Canada, a justice official in a Trump government with information about Russian interference would be compelled to blow the whistle to PSIC. Casting no judgment on any incumbent commissioner, it is absurd to think this would work. The budget is not independent. It is entirely independent on government, more specifically Treasury Board. And we can see how government could neuter the office by cutting the budget. As Tom said, all disclosures must be protected. Regarding Forum, it is absolutely essential that whistleblowers have access to our courts of justice. Retaliation is reported to be run around 85%. They deserve access to our courts, not a secondary process. Remedy. Tom spoke to this very powerfully. Whistleblowers who suffer reprisals must be made whole. Corrective action and public accountability. Again, Tom spoke to this. Until the government gets serious about taking corrective action and leading by examples, nothing will change. In conclusion, the task which this committee faces is not an easy one, but it is a clear one. Commit to freedom of expression and embark upon drafting laws which respect this right. The evidence is overwhelming that the current law is fatally flawed. You must take action. Remember, there are 2 core principles. 1, investigate the wrongdoing and order corrective action. And 2, ensure that the whistleblower gets redress. The current law is focused almost entirely on a strict regime, dictating and controlling how public servants blow the whistle. Protection is almost an afterthought. I end with saying this. This year, Canada celebrates 150 years of a proud and rich history. This committee has a unique opportunity to contribute to this milestone. I ask you to take the steps to finally secure meaningful and legitimate whistleblower rights for our public service and protect the inalienable principle of the public's right to know. Thank you very much for this opportunity.
Thank you very much for your testimony. Colleagues, as I mentioned before, we will have one 7-minute round, and we will start with Mr. Whalen.
Thank you very much, Mr. Chair, and thank you, Joanna, Tom, and John, for your passionate testimony this morning. As our hearings proceed, I'm led to believe now that what we've have before us isn't a protection act against disclosures or something that would protect whistleblowers, but it's almost an act that seems to protect wrongdoers more. Tom, you have some prepared remarks that appear to look at the Canadian law in the context of your international best practices. And I'm wondering if you could provide, and maybe all the witnesses could provide, a copy of their written prepared remarks so that the committee has them available for our deliberations. Would that be possible?
Yes, sir.
Okay. Did you reach all 10 points in your remarks, or did you have anything that you wanted to add before you clued up?
Sir, I was able to cover all the points that were in the best practices that I thought were particularly significant. One additional loophole, however, in the law is not covering all the whistleblowers who have significant evidence to disclose. The law doesn't cover intelligence agencies. It doesn't cover people in the military. It offers only token protection for law enforcement. And this is not consistent with international best practices. Sir, the one point that I didn't have a chance to make that I'd like to second from Ms. Galtieri with an exclamation point is the need for a legitimate process as the foundation for modernizing and making over this law. A whistleblower law which is just imposed by the experts will not have the necessary base of legitimacy for the rights to be affected. And if there's not cultural acceptance, if there's not a cultural revolution, the legal revolution will be irrelevant for all practical purposes. And I think a good contrast is some of the European countries that have made whistleblower laws. Romania has a beautiful whistleblower law on paper, but it was just dictated and shoved through their parliament, and it's been irrelevant in practice. Serbia had a series of town hall meetings across the nation to get input from the citizens. It had over a year's worth of summits with all stakeholders represented, media, labor, the Chamber of Commerce for corporations, prosecutors, the regulatory agencies, the parliament, the law enforcement agencies, until there was a consensus on what way to structure the rights most effectively so that they would have the most impact on their culture. On their society, be the most compatible. And I hope that this hearing will be the start of that sort of grounds-up process in Canada.
Thank you very much. That's an interesting take on it. We are operating under a regime that we currently have in place as it stands. And this is a question open to all three of you. You've spoken about the need to be able for the whistleblower to choose their form of disclosure. And our act sort of has a one-stop shop. People are forced to go through the process set out in the act. In your in the countries that you've looked elsewhere, has there been a dramatic or a marked increase in the amount of whistleblowing that is able to take place, more wrongdoing uncovered in other jurisdictions where they have a more open regime where whistleblowers are protected if they go to media or law enforcement?
Perhaps we'll start with Mr. Devine, and then we'll just go to Mr. Devet, and finally, Madame Gualtieri. Mr. Devine? I'm sorry, we don't have audio. There we go.
Thank you, sir. Yes, there's a much higher volume of whistleblowing disclosures when you don't have those arbitrary restrictions. Whistleblowers have probably been the most dynamic political force in the United States in recent years, at least in the level of individual issues, if not elections. And one of the premises for our law is that public freedom of expression has to be protected as a rule rather than the rare exception, because the government relies so much on the public record for its own oversight of law enforcement. And that's been a premise in our rights since 1980, and it was recently upheld by our Supreme Court in a 7-2 decision that involved a case where public freedom of expression by a federal air marshal may have helped to prevent a more ambitious rerun of 9/11 when the government was asleep at the wheel. This is an essential component.
Mr. DeVette, please.
Yeah, well, we've seen between 150% and 200% increase in calls to our helpline, which provides legal advice to whistleblowers, provides access to legal advice since the legislation here was introduced. And I guess the most important feature or impact from the legislation, which I didn't get to in my presentation, is the salutary effect it has for both employers and employees. Up until 2014, as I explained, there were around 18 pieces of legislation on the statute books. This patchwork quilt of legislation protecting private sector workers differently from public sector workers created enormous confusion and uncertainty amongst whistleblowers. And what the Protective Disclosures Act has done is set one standard for all employers that they have to meet and makes it clear to employees that they have options when reporting. Now, the distinction that perhaps we'd make, and perhaps with the call for endless opportunities.
Thank you. Unfortunately, I'm going to have to cut you off there to allow Madame Guerrieri a brief response, if you could.
Very briefly, I think fundamentally, the idea that we impose a regime on people who are serving the public interest is just wrong. And I would say this. In the last 20 years since I started, or commenced my speaking out about wrongdoing in foreign affairs, you can see that the energy around whistleblowing in Canada has dissipated. We were starting to feel enlightened, and I have to tell you that the support I garnered from Tom Devine, he was the very first outside contact I made in September of '98. That was critical. We have regressed since then. So we have to renew the public debate.
Thank you so much. We'll go down to Mr. Clark for 7 minutes.
Merci, Monsieur le Président. Bon matin à tous. Merci à vous trois d'être avec nous aujourd'hui. C'est très apprécié. Monsieur Devine, je voudrais vous demander, là, premièrement, je lis ici dans notre briefing de documents du comité que vous avez défendu au-delà de 5000 divulgateurs. C'est quand même impressionnant. Vous et votre bureau, j'imagine. J'aimerais savoir, est-ce que vous pourriez nous partager des traits communs que vous avez identifiés parmi les divulgateurs? C'est-à-dire les causes qui les amènent à divulguer, quelle a été un peu la conclusion de leur cause? En fait, les traits communs, là. S'il y en a, bien sûr. Okay, so I can speak in English anyway.
Were you, let me just clarify, I'm sorry, Mr. Devine and Mr. DeVette, are you able to hear the translation?
No, sir.
Okay. Okay, so Mr. Devine, I'll just speak in English. It's not a problem. I've read into the resume of our committee document that you defended up to 5,000 whistleblowers, you and your office, which is quite exceptional. I just wanted to know, have you identified any common traits in all those cases?
Sir, I'm sorry, our sound was a little bit poor. I know that you asked me about common themes in the whistleblower cases. Is that the query?
Yeah, exactly.
Correct. Is there any commonality amongst the 5,000 cases that you have worked upon?
I think there's two common themes. One is the whistleblower's motive for speaking out that's universal. Whether it's something we put a positive or a negative value judgment on, they had to exercise those free speech rights in order to be true to themselves. If they hadn't acted on their knowledge, for better or worse, for good or bad reasons, it would have haunted them for the rest of their lives. It's something intrinsic to us as citizens of a free society. The second common theme is that these were people challenging abuses of power that could not withstand independent scrutiny. And that's why whistleblowers are so effective when they work with us. They're exposing misconduct that can only be sustained if it remains secret, if people don't know about it. And that's what makes this law so powerful in terms of its potential to have an impact for change. And why whistleblowers really, in my opinion, since the time of religious leaders like Jesus and scientific leaders like Galileo and Copernicus, whistleblowers have been the people who have changed the course of history.
Also, you spoke, you compare our law, which is just black ink on the paper, with other laws, of Zambia, for example, or the law in the United States. And as you know, of course, the culture changed everything. And you spoke about culture. Also, Madame Gualtieri spoke about, education and to make the public more sensitive and the grassroots people. So I guess you were speaking about public servants and Canadians in general. But I'm not sure if we can correctly, if we take into account the cultural aspect, I'm not sure if we can correctly just, compare laws between each other. Like, for example, we are always told that in the United States there's a huge culture of whistleblowing since forever, and which is not the case here. So you spoke about, the importance of having a good due process procedures, to have a tangible support, a village of people supporting each whistleblowers. What would you propose to us? And the question goes to all the witnesses. What kind of proposal would you have for Canadian people to induce some cultural, cultural impetus to whistleblower? Impetus?
If I could ask all three witnesses to respond, but for only about a minute each, I would appreciate it greatly. And Ms. Gualtieri, we'll start with you.
I speak to university students. In fact, I'm going next week to Western University, and I can tell you that they simply do not understand what is at stake here. And until we change that, and once they do, they are engaged. They feel enormous enthusiasm. I met with a journalism student a couple weeks ago, and journalism, I was stunned. She said, very few of my colleagues know what whistleblower means. So there are ways to do this. Tom talked about Serbia, and he said what they did in conjunction with passing the law, they had town hall meetings across the country. We can do that. And I tell you that once we engage in that kind of outreach, the culture will change.
Mr. Devine, do you have a response? Mr. Devine, do you have a response? Briefly, please.
Yes, sir. No matter what the culture, the magic word for any society is consequences. And what's made whistleblower laws popular and what's made the reason they've spread so much is effective education about the consequences, the tragic consequences that could be avoided if it weren't for secrecy, and the disasters that can be prevented when we have the knowledge to act in a timely manner. And that's why whistleblower rights whistleblowers have gone from being pariahs to really on a public pedestal in the United States, because they have made a difference. And the more that your process can foster not just strengthening the law, adding more teeth to these rights, but getting the word out how this can make a difference, changing society, helping people's lives, preventing unnecessary
Thank you.
disasters or tragedies, you'll have the political support.
Thank you very much.
Whistleblower rights.
Finally, Mr. DeVette, very briefly, please.
Sorry, if there's one measure you can take to change culture, it's to create one single standard by which employers and employees have to meet when making disclosures, and having one single, simple, strong law in place is better than having 20 on the statute books. And that's the approach the Irish government has sought to take. It's one that has gained ownership and buy-in from employers, trade unions, public bodies and regulators. And in our own survey of attitudes towards whistleblowing recently, we found that between 90 and 95% of employers said that they supported whistleblowers even where they're disclosing confidential information. So it's important to have one single law on the statute books, and a strong one.
Thank you very much. We'll now go to Mr. Weir for 7 minutes, please.
Thank you, Mr. Chair. I'm kind of stunned that we've had 7 minutes of conservative questioning that did not pick up on the point about gag orders as they relate to the procurement of Super Hornets. So I would actually like to ask all of our witnesses how they would reconcile exempting whistleblowers from secrecy agreements or gag orders with the genuine need to read in officials who are involved in the procurement of things that include commercially sensitive information.
Mr. Devine, do you want to start?
Sure. This has been a topic which has been heavily analyzed in the United States, and the Whistleblower Protection Enhancement Act of 2012, which was passed after 13 years of study, has 4 what we call anti-gag provisions in the law. The principle is essential because otherwise agency secrecy agreements can cancel out the statutory free speech rights, or settlements can make a joke of the quest for justice by sacrificing the public interest. But there has to be a responsible balance. The boundaries in the United States are that if information is marked as classified for military reasons, or its release is specifically prohibited by a statutory provision by our Congress or your Parliament, that you can't publicly release that information. Any other restrictions, however, are superseded if the information is covered by the whistleblower law, if it's evidence of illegality or threats to public health or safety or mismanagement. You don't have the free speech right to make a blanket disclosure, but that particular part of the information you cannot be gagged from, and that's been in every U.S. whistleblower law since 2000, because without it, the laws would be circumvented easily.
Mr. Weir, did you want to have responses from all witnesses?
If the other witnesses have something to add on this, that would be great, but if not, I have many other questions.
I'll just briefly address the gag order. There's just something that is so fundamentally perverse that a whistleblower who by definition steps up with information of public value is then forced into a gag order and forever prevented from speaking that which they basically made was a major feature of their life. So it's just so fundamentally wrong. And Tom has spoken to how you can go about reversing that Orwellian maneuver.
Mr. Devitt?
Yeah, sure. The Irish Protective Disclosures Act under Section 23 prohibits an employer from forcing an employee to sign a gagging clause. So it's very clear, irrespective of what. There are exceptions for those sharing information that might be related or have an impact on national security, but where public contracting is believed to be subject to wrongdoing, there are no provisions to prevent an employee from sharing information or from making a protective disclosure about that.
Mr. Weir, you've got about 3 minutes left.
Well, thanks. I think that today's testimony suggests that we really need to overhaul our Public Servants Disclosure Protection Act, but assuming that we were able to get a strong piece of legislation in place, I wonder how often should it be reviewed? The current law speaks to a review every 5 years. Our committee is now reviewing it for the first time in a decade. I just wonder if our witnesses have any thoughts about what the right type of review period is.
This time we'll start with Madame Gualtieri.
I think that if the law is an effective law, a legitimate whistleblower protection law, then you test it by see how it's working. If there is a need to review it, then you can take measures to undertake that. But the first order of business is to get a law in place that is our best effort, follows best practices, and let it do its work. I have no strong views about imposing a statutory review in the law. I think that if it is imposed and not necessary, it could waste a lot of public money. So I think that you test to see how the law is working through real-life examples of whistleblowing.
Thank you. Mr. DeVette, do you have a comment?
Yeah, the Protected Disclosures Act is due to be reviewed again this year, so it's 3 years after it was originally enacted. So I'll just make it clear as well, the Protected Disclosures Act covers both public and private sector workers and those in the non-profit sector too. So it's not just a public sector whistleblower act.
Mr. Devine.
I think, sir, that the 5-year period by statute is a reasonable one if you're going to have a structure for official review. But review should be something that's ongoing and continuous. Groups like ours are constantly evaluating the trends and how the law is being interpreted and enforced, and then informally briefing folks like yourselves in Congress so that they're aware of the latest trends and developments. Our Congress, on the average, has oversight hearings for comprehensive assessments of how the law is working about every other year, just through legislative hearings like you're having today.
Thank you very much.
Question for Mr. Devitt. Ireland has been upheld as the gold standard for whistleblower protection, so I appreciate your testimony about the Irish system, but I do wonder if you've had a chance to look at the Canadian law and if you have any specific feedback on it.
We only have a few seconds left, sir.
Sure, okay. I think one of the flaws in the legislation, as I understand it, is that it is restricted to protecting workers in the Canadian Public Service or in Crown owned companies. This leaves private sector workers and those working in the non-profit sector unprotected. I think the fact that also the PSIC is required to give clearance or forward on complaints about retaliation to a judicial body may prevent those cases where there is merit to the claims from being heard. In Ireland, there's no barrier to seeking redress to the courts.
Thank you. Our final intervention will come from Madame Ratanzi.
Thank you all. You've given us a lot of testimony, Madame Ratanzi. Madame Ratanzi, yes. C'est la second round. You've given us a lot of food for thought. And considering that this law was written in 2007 and we're doing its first review, and considering that it's not probably feasible to rewrite the whole thing, there must be some low-hanging fruit that we can capitalize on. For example, Mr. Devine, you talked about the Canadian law is a paper shield and not a metal shield. How would you make it a metal shield? We heard about the gag orders. We heard about the good faith clause being removed. What else would you do to make it a metal shield?
I think the first cornerstone would be to eliminate the arbitrary restrictions on when protection applies. so that it applies whenever you're not engaging in some sort of illegality by blowing the whistle. There shouldn't be artificial restrictions that it's written or oral, or that it's to a certain person or not another. The second cornerstone would be to give whistleblowers access to court if they don't get a timely ruling from the PISC. In the United States, usually the cutoff is about 180 to 210 days. If your informal remedy hasn't produced results by then, you're free to go the next step and graduate to a due process remedy. The third cornerstone for improvement would be adding in the modern burdens of proof that are part of the best practices for every recent national or intergovernmental whistleblower law. And the fourth cornerstone would be adding in the premise that you will be made whole if you prevail in your whistleblower retaliation case, so that you're not worse off even though that you've won. You can add all four of those premises without dismantling the portions of the law which are currently in existence.
Thank you. Madame Guattari, I am so sorry that you were called the enemy of the state, because as a whistleblower, there should be a protection. And you talked about, and I think Mr. Devine talked about PSIC being a toothless, I called it a bulldog, but a toothless agency. And you mentioned full free speech rights. What do you mean by that? Where should the whistleblower go? Go straight to the media? Go straight to other agencies? And I have, if you say media, then I have a little bit of a concern, and I'll explain why. Sometimes media likes to sensationalize the message. So how would you ensure that whatever you say, the content is what they report, not the headlines?
One thing that has not been discussed here today is what in reality how whistleblowers work. I reflect that, but most of the people I've talked to, especially when you're talking about systemic wrongdoing and not individual acts, somebody stealing a TV or something of that nature, but systemic wrongdoing that permeates a government department, as in my case, the whistleblower spends generally a tremendous amount of effort trying to effect corrective action and be heard inside the organization. I did it for 6 years, right up to the minister's office. Going to the media was not something that I relished. It's not something that I had no experience in it, but what were my options? Going to the media was the last step. So what has to be demonstrated is that there is an agency or a process in place that truly enables the whistleblower to be heard, to participate in the investigation process, not be disenfranchised. They have to be part of the whole development of what is actually being exposed and investigated. Whistleblowers do not run to the media. And Tom would, I believe, fully endorse that. Also, I think we have to remember, though, that the media historically has been the channel or the avenue by which we, the public, and you, the politicians, have been informed about systemic wrongdoing.
Thank you very much. We heard from a lot of witnesses, and some of them had said, okay, you need to strengthen your internal processes, and you have been subjected to the internal processes that you utilized. And they said, make the Public Service Integrity Commissioner more proactive rather than reactive. What would you say to that? And I would like to get the other two's opinion on it as well.
I'm not entirely sure what you mean by being proactive. I'm going to ascertain that you mean that they should go out and kick off investigations by themselves.
That's what was suggested.
I don't think that the office has the resources to do that. There will be plenty of public servants who, with a belief and a trust in the system, will come forward with information that will keep the office very, very busy. So, I think, again, Tom has highlighted that there really are two issues. There's one, the need to examine the wrongdoing, and this act essentially attempts to do that. Get the information. You got to remember, it's called the Public Servants Disclosure Protection Act, not Disclosure Protection Act, but Disclosure Protection Act. That's an important distinction. So we have to investigate the wrongdoing, but we also have to have a body, not bifurcated the way it is now with the tribunal, a body that can very quickly and effectively take steps to protect and, if necessarily, provide a remedy to the whistleblower.
Mr. Oh, my.
Unfortunately, we're out of time. And I do apologize again to all our witnesses. I think if we had the adequate time, we'd probably be here for several hours because your testimony has been extremely informative, and I can assure you on behalf of the committee, extremely helpful to us in our deliberations. I would ask that all of you, however, should you have additional information you think would be of benefit to our committee, please submit that through our clerk so we can include your additional testimony in our deliberations. Thank you once again for all your appearances, and we will suspend now, colleagues, for a couple of minutes while we wait for our additional and next witnesses to approach the table. Colleagues, I think we'll get going as quickly as we can. We're running a little overtime. We do want to give adequate time for all of our witnesses to provide testimony and have our colleagues around this table ask questions, but we're going to have to get to it quickly. I welcome all of our witnesses here. I know you've been observing the testimony in the first hour. I would ask if you could possibly keep your comments as brief as possible, as succinct as possible, to allow as many questions as we can in the brief time that we have before us. Mr. Conacher, welcome again. I haven't seen you for a while since I was on Procedure and House Affairs Committee, but thank you for being here. Madam Myers and Mr. Garrett, thank you as well. First on my list is Mr. Conacher, so your opening statement, sir.
Thank you very much to the committee for the opportunity to testify today. My name is Duff Conacher. I am co-founder of Democracy Watch, which started up in 1993. We now have 45,000 supporters across the country and another 100,000 people who have signed petitions in support of one or another of our campaigns, including our campaign to protect whistleblowers who protect Canadians. More than 21,000 people have signed a petition. The leaders of each federal party would have received those letters. And that's just in the last couple of weeks. A petition that we launched just 2 weeks ago on change.org. And it calls for 17 key changes by the federal government, not just to strengthen the Public Sector Disclosure Protection Act, but to strengthen whistleblower protection overall. And whistleblower protection is not only needed for public sector workers, and I know the system is currently open to anyone who might want to file a complaint with the Integrity Commissioner, but the Integrity Commissioner would have difficulty protecting people from retaliation who are outside the public sector currently. As well, private sector workers in federally regulated institutions are not protected by the law, and the overall system for private sector workers is very inadequate. There are some protections under competition law, labor law, environmental law, but the education as to where to go and the entire system of protection is far too weak, as it is for public sector workers. So the petition calls for 17 key changes to the federal government system to ensure that everyone who blows the whistle on business or government wrongdoing in the federal sector will be fully and effectively protected. As the current banking service scandal shows, such protection is needed, not just for public sector workers, but for all federally regulated business workers. The 17 key changes, and I won't go through all of them in detail, but happy to give you detail, and I have made a submission to the committee, so you will have them, and they're set out in the petition, are first, ensuring everyone is covered by the protection law and system, including political staff, and also including CSIS, RCMP officers in the military who are currently not covered by any system. Allowing everyone to file their complaint directly and anonymously with the Protection Commissioner. That commissioner should not only be the Public Sector Integrity Commissioner, but at the federal level, we are proposing that there be a private sector central office set up to cover anyone in the federal private sector, and it would be a clearinghouse ombudsman-like office that would help them find the law enforcement agency they should go to, while protecting them as soon as they file a complaint. Ensuring the Protection Commissioner is fully and independently appointed and empowered to impose penalties. First of all, in terms of appointment, Ontario has the best practice appointment system. They only, unfortunately, use it for provincial appointed judges. An independent commission does a public merit-based search, comes up with a short list, submits that short list to the minister, and the minister has to choose from that short list for any position that's open in the bench, in the provincial bench in Ontario. That system should be used for all cabinet appointments, especially anyone involved in law enforcement. Currently, the ruling party chooses the Integrity Commissioner, all the other officers of Parliament. The opposition parties are consulted, but they don't have any power at all. And instead, an independent commission should be set up as Ontario does. It's the best practice in the world. Requiring the Protection Commissioner or agency to conduct audits and rule on all complaints publicly in a timely manner with the identity of all wrongdoers made public. Currently, the Integrity Commissioner is using the Privacy Act, a discretionary measure under the Privacy Act, to hide people who are employed by the public who have done wrong. It's just a bad idea. Those people can leave, and someone else may hire them, never knowing that they've actually done wrong. They may transfer within government, and the other people in a different government division don't know that they've done wrong. It's a discretionary measure under the Privacy Act. There's no reason at all to hide the name of a wrongdoer. And unfortunately, the Integrity Commissioner is abusing that discretion currently, and it should be taken away from the Commissioner. The Commissioner should also have the power to impose penalties, administrative monetary penalties, as a frontline enforcement officer, so that we don't have to go through the whole process of the tribunal every single time. Next, whistleblowers need to be compensated fully for legal advice that they need, and they should also be rewarded adequately if they are reporting wrongdoing that is proven. And that is because whistleblowers stick out their neck and often either have to leave their job or move their job. In the U.S., it's a 10% rule, essentially, for both private and public sector whistleblowing. They get 10% of what they save the government, or in terms of a fine under the securities law. We don't necessarily have to go that high, but I think at least 1 year's salary should be provided to somebody who's, and also priority in transferring within government if their allegations are proven. Finally, a couple of quick ones. Allowing everyone to appeal to court if they disagree with the Protection Commissioner's ruling, making sure that's set. A very important measure in the U.S. was proven that you need to reverse the onus so that the employer would always have to prove that retaliation was not taken against the whistleblower. If you leave it that the whistleblower has to prove it, in the first 2,000 cases in the U.S. where that was heard, the whistleblower lost every time, because it's very difficult to prove retaliation often. And finally, ensure an independent audit of the protection system at least every 3 years. The federal Liberals have promised open government and openness by default. If the Liberals do not strengthen the whistleblower protection law, they will not be able to keep that promise. You cannot have open government if whistleblowers are not protected fully and effectively. I welcome your questions. Thank you very much.
Thank you very much. Appreciate the economy of words. Madame Myers, please.
Thank you very much. C'est un très grand honneur d'être ici aujourd'hui and to be in Canada. I'm a trained lawyer and called to the bar in Ontario, but I'm also a lawyer in the UK of the Law Society of England and Wales. And my career working on whistleblowing has been in Europe and in the UK. But I just wanted to say that from a Canadian point of view, that I think I started into this work because it seemed Canadian to me. It seemed to be about doing the right thing genuinely, honestly, when you come across wrongdoing. And in the UK, it was very much from a good governance, better regulation, good government point of view. And so the law looked at it. Also, I think one of the things that you do need to keep an eye on is that most laws that are being developed and have been developed around public interest whistleblowing are both around the protection of the whistleblower, but also very much about freedom and access of information, the public's right to know in the end if they're being put at risk and their lives and their taxpayers' money is being misused. So I think just to also explain that I worked a lot internationally because, like Tom Devine at GAP, there are a few organizations that do this work. Where we were in the UK, where I was deputy director for close to 9 years, we actually helped draft the law that was put on the books. And organizations and governments and lawyers and jurists and parliamentarians came to us over the years. And so in the end, I've set up a Whistleblowing International Network with civil society organizations, a lot of lawyers, public interest lawyers, to talk about the tools and why this is so important internationally as well as within national jurisdictions. And I think actually this work you're doing is deeply important for Canadian democracy. One of the things I think that you've heard is that the object of the law seems a little bit already, if you read the preamble, just very limited. So in 2005, I do remember when the law, because I was interested from afar, came across my desk, it felt like it was a very small step. in a small direction. When I look at it now, it seems incredibly limited. And I think that what has happened internationally is that the world has moved on dramatically. And I think also you're not looking, I think the law is not looking at it from the point of view of public interest information being dealt with properly, any information that discloses public interest issues, protecting those civil servants and others who raise those issues. And it's also being too restrictive in the way it's meant to go through a process. So I think that one of the things is to look at, and one of the things that the UK system did, which was very much look at protection as a way to facilitate the free flow of communication. It did not put any duties on the regulators. There was considered to be a system where different bodies had different regulatory authority. If they got information, it was within their mandate to deal with it, then you'd be protected for going to that body. So I think it was very much part of building on already a British system. But some of those regulators, as we've been through a period of deregulation and light touch regulation, there's been a lot more perspective on making them do their jobs. And so duties and responsibilities of the institutions to investigate and to deal with the issues has been greater and greater internationally. So I think one of the ways to think about it is accountability rather than how I blow the whistle and whether I do it right or not. But who is responsible if there is harm? Who has to account for that? And I don't mean scapegoating. I mean explaining your conduct. And closed systems of addressing information and protecting individuals always need the potential that they will be asked to explain that to an oversight body or to other systems. So when I look at the Canadian system now, although there are the bits of independence, it looks like a closed system for the public service to deal with things, and even in the preamble, to maintain confidence in the institutions of government. That's an outcome for dealing with public interest information. It's not the goal. If the confidence is rightly judged not to be high enough and it needs to change to regain it, you need to know about it. So I think that that's where I see in just the purpose of the law and how it's been set up to be a little bit less than actually dealing with the information that could put people at risk and damage. You've heard a lot about the public-private split, and that, again, was never part of the UK system. It did fit in with the employment protection system, covered anyone with work. And in fact, they've extended it from being employees and those legal definitions to contractors, to interns, to all sorts of people who come across wrongdoing. If you think about it as an early preventive method of dealing with things, you want people who come across wrongdoing to speak up early. So again, that's where I would think that the definitions and scope of the information in your law is too high for the early protection to happen. When people start to face retaliation or a shutting down of a system that doesn't want to be questioned, they become discredited over a long period of time. So you need to think about earlier protections, earlier, closer to the problems, and as well make sure that there are the roots outside, so those who are early responsible have to explain. And that's where you have the safe alternatives to silence. Direct access to remedies, I think you've heard a lot about that. I'm happy to talk further about that, but that's a natural justice issue, and not having that doesn't make a lot of sense. And I think as well, I think that there seems to be a sort of fundamental confusion around the scope of the public interest, about it being around conduct of individuals. But I think in the reprisal element, I think it's really important to think about detriment not being a j'accuse situation that you have to find necessarily a wrongdoer in terms of the reprisals. And I think that you may have heard that the scope in the UK is around any detriment suffered, which is about not getting good evaluations, on not having the career advancement. There'll be a lot of people involved in those decisions. There may not be someone out to get someone because of their disclosure, but a system that's starting to discredit them, that's not questioning, and that just carries on. I think that the idea that I've heard some statistics that maybe 50% or more of public servants in Canada at the federal level might it's higher. That I find that shocking, that might feel either that they aren't able to speak up and out about any kind of wrongdoing or ethical misconduct, and feel that they would be protected as part of their public service. So I think there is a number of issues around the scope, the duties and responsibilities to respond to disclosures, to making sure it is covering a wide range to fulfill the purpose of the Act, a wide range of people who would have information that would be of value, that you're looking at it from who might be accountable for the wrongdoing, rather accountable for the way that they tell you about it, direct access to remedies, and finally, access to information. We've talked about the gag orders, but the idea that even the information that the Public Sector Integrity Commission's office receives is somehow never to be put in the public domain. I'm not sure if I've understood what the rules are of access to information of the P6 work over years, if that is not something that can be eventually understood by the public. Those things, I think, are quite serious issues if you're talking about this as both a transparency and an accountability piece of legislation.
Thank you very much. Finally, we have Mr. Garrett.
Thank you for the opportunity and privilege to attend here today. I was raised on a farm and started working as a carpenter apprentice and in the logging industry as a faller. In 1982, I became a bonded contractor at 27 years old, which allowed me the freedom to tender publicly funded projects. That is until I was put out of business by the federal government. In October 2008, I was invited to tender a project at Kent Prison, replacing porcelain sinks and toilets in 160 cells with stainless steel fixtures. I was the low bidder and awarded the contract. That is when the problems began. On the first day on site, after unloading materials, I was told that we could not proceed with work due to a snag. I received no explanation and eventually learned that snag was asbestos. I later learned that Kent had just been seriously contaminated with asbestos exposures by allowing a contractor to grind floor tile that contained asbestos with no abatement procedures. The guards discovered the release, and after serious exposures to them, the inmates, and also workers from that contractor, apparently the guards took job action. We were restricted to installing sinks only. Public Works then suspended the toilet installation by 5 weeks. Toilet installation required rebuilding leaking valves, but unknown to me and my crew, those valves contained very high concentrations of asbestos. No one told me this. I found this out through my own inquiries. By this time, I, my crew, and many others in the facility had been already exposed. When I reported this serious matter, instead of acknowledging the problem, I was treated as the problem. It seemed that every effort was made to deny what had happened and to punish me. I reported this to the Oversight Branch of Public Works under the control of Barbara Glover. They conducted an investigation with Margarita Finn from the Special Investigations Department coming to interview me in BC. Now there was a spark of hope. To my astonishment, their verdict was that there was no wrongdoing. I've gone nowhere with other agencies, so PSIC was my last hope. I submitted a disclosure of wrongdoing. However, dealing with PSIC turned out to be a nightmare. For example, they obviously gave my case very low priority. It eventually took 24 months to complete their investigation. At one point, they told me they could not speak to me because I was from the private sector, even though I was the whistleblower. In all of the 2 years trying to communicate with PSIC, I probably had less than 2 hours of conversation with them. They kept me in the dark nearly all of the time regarding the status of my case. Eventually, a contractor investigator was assigned who seemed very competent and thorough. She told me that based on the evidence, it looked as if there was serious wrongdoing. She planned to come to BC to interview me and made a list of 29 questions that she felt needed to be answered before that interview. Everything went quiet. I found out after several months that her contract had been allowed to expire rather than complete the investigation. A new investigator, a member of PSIC staff, was assigned who wrapped up everything in a few days. He never spoke to me or key witnesses nor attempted to have the 29 questions answered. The conclusion from the Integrity Commissioner, Mario Dion, was that there was no wrongdoing. Relied upon the assurances from the two departments who were implicated in the alleged wrongdoing, PWGSC and HRSDC. His letter contained a reference to an asbestos-containing materials, or ACM, survey done for Kent Prison in 2004. Before receiving P6's decision of no wrongdoing, I did not know about the existence of that report on Kent, although P6 did. This was new information to me. For over 5 years, I had been asking for information about asbestos in the Kent prison. Eventually, through ATIP, I received the ASIM report. Here it is. On page 3 of this report, the primary contact reference was Michael Kashoni. He was the person who had invited me to tender and also the project manager or the project officer of my contract. Both Public Works and PSIC had hidden this document from me. This is a document that, had I been shown it at the start, would have saved me, my crew, and others from exposure to deadly asbestos. In fact, I did not need the whole document, only the following 2 sentences, and I quote, ACM gaskets are most likely installed on all mechanical systems, i.e. domestic water throughout the facility. However, once these materials have been installed, they are hidden from plain view, impossible to find without dismantling the system. Therefore, ACM abatement procedures should be exercised when this material is disturbed or removed during service work. Straight from the report. I repeat, this is the document that Public Works and PSIC hid from me and from other witnesses while arriving at their conclusion that there was no wrongdoing. If I had known about this document, do you really think that I would have exposed myself and my crew to asbestos? If I did, I would have been faced with huge fines from WorkSafe BC and most probable lawsuits from others. Throughout the confusion of all this, I was supported by Alan Cutler and David Hutton. David offered to review the documentation that I had assembled and wrote a 17-page report which has been entered into the evidence for the committee. This report explains how PSIC concealed vital evidence from me and hobbled its own investigation. Today, my circumstances have changed unimaginably. I have lost my bonding status and my business is bankrupt. My health may be at risk. I never know when I might receive a diagnosis of asbestos-related disease that is a death sentence. I'm now estranged from business associates, friends, and worst of all, family, who believe that I must have done something wrong to cause all this. Clients, both public and private, have quit calling me for work, an unofficial blacklist. This dispute with Public Works has overtaken my life and taken a serious toll. Many think I now have mental problems. In some respects, they are correct, as I am on a path of becoming seriously affected by PTSD. I'm now the primary caregiver for our adopted daughter, a Romanian orphan with special needs who requires full-time attention. At times, I feel I am scarcely hanging on to my sanity. Yet the government's still not finished with me. I've lost a lawsuit against them, but I've been told that Department of Justice will have a whole team of lawyers lined up that could run up my legal bills into additional tens or hundreds of thousands of dollars. Both my father and grandfather served overseas in past world wars, and they believe they fought to preserve our Canadian values of freedom and common decency. And in their honor, I'm doing the same in a slightly different way. Where do I turn to now? Do any of you know of a way that I can finally get some help without further confrontation? Thank you.
Thank you very much, Mr. Garrett, and thank you all for your testimony. We'll start with our normal 7-minute rounds, and Monsieur Drouin. 7 minutes, s'il vous plaît.
Thank you, Mr. Chair, and I want to thank the witnesses for being here today. My first question, I'll deal with a few points that Mr. Conisher brought up, but I want to talk to you about culture. And maybe, Ms. Myers, if you have some experience around the world on how much emphasis do you put on culture? Because I know we have an act here, but it's back-ended. I mean, that's when the worst-case scenarios happen. So how much focus do you put on culture within government to ensure that when there are issues that arises, there is that level of confidence and people can declare something's wrong, and there's that level of confidence within the bureaucracy that people are comfortable. So how much focus do you put on culture?
Well, focus on culture without offering some clear, rational ways in which to raise things has a mixed message. So I think people are incredibly smart and rational. They will have understood that somebody's tried something and it didn't work. And that's the message that gets around culturally much faster than what works. So the proactive side of making sure that if you have a system that you're going to rely on and that you tell people about it and that you do that really well is incredibly important to start to change the culture in terms of confidence in the system in place and being able to speak up. I think culturally in Canada, you won't have much difficulty in saying it is your duty and your responsibility, not in a legal way, but the duty can be, but your responsibility as someone who's providing a public service, and even within private sector companies, they're providing services. One of the backgrounds to public concern at work was consumer protection. Most of the background was actually private sector disasters. So a sinking of a ferry, the explosion on an oil rig, and a bank that collapsed before we had the financial meltdown. You don't get a lot of pushback culturally if you're talking about why you're doing it in the public interest, and you're appealing to people's values and sense of wanting to do a good job, and you're providing them ways in which they can make sure that the people who are responsible and who will have to account for wrongdoing know about it and do something about it. Most of the shock is when that doesn't happen. So I think I understood at the very beginning that there are, or in different parts of the world, there are bodies within government who deal with civil servants' code of conducts and ethics and deal with that. This is where I think this act got a bit confused, because it did that along with wrongdoing, raising it somewhere, and also potential reprisals or detriment. So it's trying to do an awful lot at once, and it doesn't seem to be doing anything very clearly for people. And confusion and the questions people have, if you think about it, that's the default to silence.
And Mr. Conacher, I'll get to you in a few seconds, but with regards to your point number 4, recommendation number 4, and I want to ask from both of your experiences across other jurisdictions, with regards to priority transfers for whistleblowers who decide to blow the whistle on a wrongdoing. Other jurisdictions, do they provide staff priority to ensure that whomever blows the whistle gets to transfer a lateral move, essentially, out of the organization? And do they, from your experience in other jurisdictions, how do they, if has any bureaucrat or any public servant stayed in the same organization once they blew the whistle, and how is it realistic to think that we're really protecting their identity or their confidentiality within an organization? Is that realistic to think that we do that?
Other jurisdictions do allow that priority transfer. Is it realistic? It depends really on the size of the organization and the wrongdoing. And if only a few people know about the wrongdoing, then it is very difficult to protect someone's identity, because one of a few must have reported it. And the others usually dig to find out who it was. But in a large organization where lots of people know about something that's happened, and someone reports it anonymously, and even the commissioner investigating doesn't know, they just have enough written evidence and other evidence to actually prove a case, then the person can actually successfully do it anonymously. But it is difficult. And that's why, excuse me, those who don't want to report anonymously, who then do face retaliation, should have that compensation of being able to transfer or a reward. Just to mention, I didn't mention this when I was first presenting, but I'm sure you know and have heard that the Ontario Securities Commission has implemented an up to $5 million reward for whistleblowing on Securities Act violations in Ontario that just started last July. So we have that example now in Canada, and you can argue again about the amounts, but they're recognizing that people are going out on a limb, and that financial compensation is not really a reward, it's really just a buffer to allow you to go out on that limb without having it cut off behind you.
Okay. Do you have anything to add, Ms. Myers? Or?
Yeah, I think there are a range of tools to help someone remain whole while either an investigation is going on or there's been obvious reaction that's negative. Transfers are one of the tools that needs to be available. I've had cases where that seems like the whistleblower gets moved to get rid of the problem, and that makes everyone happy except the whistleblower, who enjoyed their job and thought they were doing their job and thought they were doing it in fact and were very, very well. So that can be a punishment in that situation. So you need a range of tools on that. I think I keep trying to find ways to think about it. A lot of the people that I've worked with in private sector who are security people started off in the police, and they just you get a range of witnesses, people giving you bits of information, and you don't expect them to prove it. You do your job, and you certainly don't put them in harm's way when you're investigating. Now, we're not talking about criminal conduct necessarily, although we might be. And I think that's the issue for public sector service, is to be dealing with this sensibly from the beginning. You know, people are smart, getting people trained properly when people come to you about what questions you're going to ask, how you're going to deal with. Sometimes that you dealing with it properly is the protection the person needs.
Mr. McCauley, 7 minutes, please.
Morning, welcome. Thank you, first of all, for your words and your advocacy. Mr. Conacher, I'll just start with you. You mentioned about protection for outside the public service into the private sector, but you had mentioned federally regulated only. Is that the intent, is just a start, or that's realistic, possible, too difficult to expand to the entire private sector, or?
I'm just talking about what's within the federal government's power. So
Okay.
the provincial governments would have to strengthen their systems for workers that they regulate under and institutions that they regulate.
Right. Mr. Garrett had, it's pretty much a horror story. How do we, and Ms. Myers as well, and Mr. Garrett kick in, how do we protect the private contractors who are working for the government so they can whistleblow without having their lives ruined, or more importantly, so the company is not, blackballed?
Well,
and if you've got experience with other countries, how they do it, please.
I mean, essentially, everyone needs to be protected, including suppliers to the government, and the enforcement has to include follow-up audits to ensure that they are not losing contracts in the future simply because they've blown the whistle. It would be very difficult for a person such as Mr. Garrett, and I'd just like to pause and actually say best wishes to him, and also note how courageous he is to be coming forward and telling this story, which really is a horror story. Suppliers are in a vulnerable position as much as anybody, and I think there has to be ongoing audits, just regular part of the practice of the commissioner, but especially in a case like this of follow-up audits, essentially keeping the case open so that a supplier continues to be protected from retaliation going on into the future, by auditing whether bidding on contracts has been fair or whether they have subtly been just taken off the list, because it's so easy to do.
Well, sorry, Ms. Myers, go ahead.
One of the ways that you can do it as a public procurement service, so this is where you're actually thinking about the bodies, the federal agencies that do public procurement, they can first of all have part of their contract that the organization must have their own whistleblowing arrangements, that staff working on the project can come directly to the contracting department with any issues, and that they will actually take action if they find out that the organization, the private sector, takes any punitive damage against that individual for having raised the issue. There are tricks of the trade that mean that you don't have to have a full legal protection system in place that allows you within that system to say, we will not deal with companies that actually shut down that information or don't have good arrangements.
Yes, I'm not as much worried about the companies coming forward. I'm worried about them being blackballed by bringing up issues of waste, mismanagement, et cetera, Through
think it's in the same.
Procurement ombudsman, perhaps?
Yeah, and it's in the same line. If you are raising issues that the government needs to take into account, that that's not a bar to making another.
We've heard about like a whole army of lawyers going after Mr. Garrett. We heard Ms. Gaultier as well, like the government going after her for several $100,000 of legal bills. Do we write that into our new laws to protect or stop the government from, going after?
Well, I think that's partly to do with a weak system of protection that they have, because if they're able to have their rights protected, then it will not make sense, both for a cost benefit for the government and for the public damage that will be done.
Great. Ms. Myers, in your opinion, Mr. Conacher as well, which countries are doing it best out there? We've heard from Australia, Ireland, the U.S. Is it a combination of cherry-picking who's the best items, or is there one we can use as a model?
At the moment, I would say the UK still has a good, solid base. The Irish law is called the Public Interest Disclosure Act on steroids by people around.
I'm sorry,
The Irish law is called sort of like the UK law, but on steroids. It actually did make some fundamental important changes. The Serbian law is a very good example of a system that did not have this in culturally, legally, the issues around anonymity. They have a good law. The Australian situation, I think you have talked to Professor A.J. Brown. They've developed and kept an eye on it. Sweden has now taken some steps which may be...
Ireland seems to be the only one that has a provision where a whistleblower can go after, has a redress through courts to go after someone who...
Yeah, it's one of the first to put that, although original laws that have been put forward to as draft bills that haven't passed before, they kind of did have that capacity built in.
Do you think it's working?
It's a very new law,
as a non-lawyer, that looks to me of a way that Mr. Garrett's, the Miss Gaultier's of the world can be protected.
Exactly, and they have
not to be punitive, but will send a strong signal if you're going to retaliate. You're going to lose your job. You could be, you'll be fired, lose your house, et cetera, et cetera.
Yes, I had mentioned earlier reversing the onus so that the employer would have to prove the retaliation has not taken place. I think that's important, and also giving the commissioner the power to levy administrative monetary penalties straight up, so that chief executives, heads of organizations in the government or private sector would know that a personal penalty could be coming their way, just not through a tribunal process that's going to take years, but just a commissioner saying, you did wrong, you're paying this fine. And if you make that significant enough. As well, there was a question earlier about the training. I'm actually doing my PhD in law, looking at how to ensure people comply with good government laws. Behavioral psychologists point to a number of things that should be part of training. One of the most important is that...
I think we might, I was going to say, I think we might be out of time. I wanted to hear from Ms. Myers quickly. She's putting her hand up.
Yes, no worries.
Perhaps we'll get to it in the next intervention, which is Mr. Weir for 7 minutes.
Yeah, sure. I mean, Ms. Myers, if you want to take a minute to respond to Mr. McCauley, that'd be great.
I was just going to say that's one of the laws. The Irish law is definitely, and from the Swedish point of view, we've talked a lot about there's tiers of disclosure routes that people can go, so that's another way. Also, the injunctive relief that's in both the Serbian law and the Irish law, which just stops it from going off on down a tangent.
One of the points we heard from the previous panel was that whistleblower protection in other countries often encompasses the private sector. So I'm very glad that on this panel we have Mr. Garrett providing the Canadian perspective from the private sector. I guess I'd ask Mr. Conacher to maybe elaborate just a little bit on your proposal to extend federal whistleblower protection to the private sector.
Sure. Well, again, as the current banking service scandal shows, the federal government needs to pass a law protecting all federally regulated workers, and the provincial governments need to do the same for their both public sector and private sector workers. We have a couple of areas covered: competition law to the Competition Bureau, to the Labor Board under environmental protection laws. But what's needed, I think, is not only a blanket law, but a place to go. where everyone will know, okay, you have a problem, this office will help you, and figure out which law enforcement agency you're supposed to go to with that particular problem. And one of the details I didn't mention was that then if you go to that law enforcement agency, if they don't deal with it in a timely manner because of whatever conflicts of interest or problems, flaws there may be there, then that central office should be able to take the case and move it forward so that you're not left hanging, possibly retaliated against, and waiting for 2 years for someone to get back in touch with you. So we have a current scandal. We have another one with the food industry and CFIA. Just reported recently that they rolled over for the food industry in terms of a regulation. These private sector scandals show the inadequacy, and likely these situations would have been prevented if whistleblowers had a place to go and were fully and effectively protected.
So, Mr. Garrett, how does that sound to you? Does that seem like the right kind of model, or do you have other ideas about how we could make this system work better for folks from the private sector?
I really have no advice. People have asked me what they would do. Like, I've had people coming to me, especially guards that worked at Kent, and they say, what can we do? Before I came here, one guard said that he has evidence of 6 different incidences of asbestos exposure in Kent Prison. And that's before, during my time, and after. It doesn't stop. I've listened to quite a bit of testimony here, and this is one subject I haven't heard, and I'd like to impress on you as parliamentarians. And it's not anything to do with my case. So much of government has been told that we need to run government like business. And there's an element of truth to that. But there's a distinct difference between government procurement and public procurement, in that so many things that are legal in the private sector are not really proper in public sector, because you have to disclose full transparency and accountability. The private sector doesn't have to do that. So there's a fundamental problem in government of believing that we need to run government the same as the private sector. That's not totally true. Yes, as far as increasing efficiency and fixing problems, yes. But, you know, I don't agree with almost the decimation of tendering process, public tendering process. It's almost gone out the window. And really, the president of the Canadian Construction Company Association should be here, not me explaining this. And, you know, we're going to RFPs. We're going to 3Ps and design build. These all work well in the private sector. They don't work well for government because they don't have accountability and transparency. It's not there. So I'm way off topic. There's got to be fundamental change. You know, I've got an email here I should have submitted. It's from senior management. I just found it before I came. You know, it says it's one high-power bureaucrat commending other bureaucrats. You know, the project managers and the contracting officer have worked closely together over the past 2.5 years to resolve this file, and could be, this is my file, by the way, and should be commended for their tenacity. Overall, the staff have been involved with the Department of Justice lawyers, the Office of Procurement Ombudsman with Margarita Finn, and Garrett's legal representatives, as well as ATIP requests for file information. This is fundamentally wrong.
Yeah, well, thanks for bringing it to our attention, and it's certainly not too late to, you know, submit that to the committee. I mean, I'd invite you to do so.
That's just one of many, many emails that has a system set up to attack the whistleblower. You know, I'm seeing it, there's a 3D process here. It's deny, delay, and eventually destruction of the whistleblower. And I've lived it. I'm living it now.
Well, no, thanks again for the testimony, Ms. Myers.
Just to say, one of the things that the Office of Special Counsel in the U.S. does and is built into their system, and one that I think if the Canadian government could do, would be absolutely send the clearest message culturally and in reality be more effective, is to not only give feedback timely to the person who made the disclosure, but actually review a little bit when you're investigating, because these people are the ones who know who the investigator should talk to, and often they're not in it to actually win big money. They're in it to either get back to their job or to ensure that those around them are doing better work. They are incredibly powerful in terms of making sure that the investigation and the ideas for how you should resolve it really clear. And I've seen that time and time again. No matter how fragile in other ways they knew professionally what they were doing, they know what the problems are, and they can be incredible. They're your resource. They were anyway before they went out of their management structure to let you know.
Thank you.
Unfortunately, Mr. We're out of time. Our final intervention, Monsieur Ayoub, 7 minutes, s'il vous plaît.
Thank you, Mr. Chair. I'm going to speak in French if you need the hearing. Merci.
Do all of you have translation? Mr. Garrett, do you have a...
I do.
English channel is now up and running.
He's plugged into a different one.
It's not the right...
He's plugged into a different one.
Joyce, it's not the right... Here, got it.
This is the English channel.
Please go ahead.
Merci.
Thank you. Thank you to all three witnesses. Mr. Garrett, thank you very much. Well, I thank you, and at the same time, I empathize with your situation and your bad experience. For some time now, we've been looking at this whistleblower issue, and my perspective is that there's an incredible number of measures that have been taken, and we're going off in all directions in Canada, or just speaking of Canada, to try to resolve an issue that, in fact, should have some basic guidelines to arrive at some objective. So many people want to get involved and are getting involved right now. Scattered effort. Ms. Myers, you were saying that whistleblowers are not there for the big bucks, obviously. But look, we've just heard that Ontario is going to provide $5 million as a reward. When I hear that, I wasn't aware of it. When I hear that, I'm completely blown away. What kind of incentive does that represent, really? Now, what we're looking for, of course, is a whistleblower who is credible and who has gone through some factual experiences, difficult perhaps. We want to protect them. I realize that whistleblowers are taking the whole burden upon themselves in a certain way. Why would a whistleblower not simply alert someone who would take the responsibility off his shoulders to either approach the federal or the provincial authorities or the municipal authorities, be the case that it is, but there would be some entity, some body that would assume that responsibility to follow up on the issue, assuming, of course, that the whistleblower was credible, and it is. Well, in France, they are. Whistleblowing is called the non-fait d'alerte, but they use whistleblower just as currently. It's a neutral term, but in English, you know, there's semantics involved. A whistleblower, some calling the shot on somebody.
Some concerns about it, but in a financial situation, the SEC is a financial, then they are paying, but they are also finding that without the protections, and even the SEC's experience in the U.S., and I've been in the same room with the person who set up their whistleblowing system, most of the whistleblowers that come to them never get a reward. It's quite limited, and in fact are doing it because it's wrong. And it put it out there. It appealed to the money-making side, and it worked works a lot in the American system. It's caused great upset in Europe as well, as has anonymity and anonymous reporting when you've had fascist states, and it's been go to only the state, and we will keep you, and we'll use it against other people. So this is another thing you have to think about, of having more than one channel for people to go to, important channels, the right channels, regulators who have the mandate to deal with the issue, managers who have the responsibility to respond, a PSIC who allows that flow to keep going to the right places, not a closed system that then isn't accountable itself. So you're absolutely right. It's about taking the responsibility for the investigation away, but not the responsibility for doing the right thing away from whistleblowers. It's not just saying, come to us like a child and you just are not involved anymore.
Mr. Conacher?
We do have an office. We do have an office, the Public Sector Integrity Commissioner, but there are literally hundreds of cases that have still not been given a full investigation and fair investigation by that office. And the current commissioner is someone who has been there pretty much through the whole time, and as far as we know, has never blown the whistle on what was massive wrongdoing by the first integrity commissioner and wrongdoing also by the second. People have tried to protect Canadians by blowing the whistle on government wasting billions of dollars, approving dangerous drugs, covering up scandals on big businesses, gouging them, selling hazardous products, covering up pollution and oil spills. Those people have been harassed, fired from their jobs, sued, silenced, and hurt by the government and big businesses. Not just the federal government, but provincial governments as well. And that's all because the laws in Canada are weak and enforcement is negligently bad. So we do have the framework of a system, but we need these many changes, 17 listed in this petition that more than 21,000 people have supported, to make the system effective, to fully and effectively protect whistleblowers. Again, you can have an argument about how much should a reward be, but best practice is to provide someone with somewhat of a buffer so they know when they're going out on that limb that they have a buffer if the limb gets cut off behind them because of negligently bad enforcement by someone who is not doing their job properly, as has happened hundreds of times in Canada in the last 10 years, at the federal level alone.
Il me reste une minute à peu près pour faire. Je comprends, je suis pas.
I think I have about a minute left. I'm not against it, but I'm just thinking about the appropriateness of it. I mean, well, in any case, I've also noted that, and you've spoken of it, that we don't have any review in a statutory regular fashion or regulatory review. Of course, the Auditor General could be requested to do so, but there's nothing mandatory. To your mind, how could we reestablish some credibility in the system over time so that the commissioner is seen to have some teeth?
I believe it's difficult to see that happen with the current commissioner, unless that commissioner would be required to commission a fully independent audit of not only the commissioner's office, but how every department is dealing with whistleblower protection. It is something that hasn't been done since the first commissioner was audited, and it's long overdue. There should be an independent audit by the Auditor General at least every 3 years of the entire system, with the results, of course, made public.
Very much to all of our witnesses. Your testimony here has been instructive and extremely informative. And Mr. Garrett, just on a personal note, words of mine could probably never express the sorrow that I have for the situation that you've endured over the number of years that you've been fighting this battle. I can only hope that the final report and recommendations from this committee will go in some small measure and hopefully a large measure to redressing the situation that you've experienced, and hopefully no other employee that has either worked for the government or has done work on behalf of the government will have to experience what you experienced. Thank you all for being here. Colleagues, I think that if we could go into camera for just a few moments, my reading of this is that based on the testimony we've been hearing over the last number of days, there may be additional witnesses that committee members would like to recommend that we hear from as we continue this study. I know Mr. Weir has indicated he has some, and I think, Monsieur, you maybe have some as well. So I will excuse our witnesses and suspend for just a couple of minutes, and we'll go in camera for about 5 minutes.